Okay, hello, my name is Obed. Today, we will talk about the rights of a person under custodial investigation. Okay, why did I choose this topic? Because of two stories that happened during the quarantine. First is about my cousin who posted something in social media, and the barangay captain sent him to jail, okay, overnight or to prison. And then a friend who called the NBI, and the NBI called him back, inviting him to appear in their office. So, how does custodial investigation play into these scenarios? All right. First, what is custodial investigation? Okay, the Supreme Court in 1997 said that custodial investigation includes questioning initiated by law enforcement authorities, and then they deprive the person of his liberty. So there's a form of restraint. Okay? And then the investigation is not just a general inquiry, meaning you're not just trying to find out who the suspect is, but you are already, or the authorities are already sure of who they want to arrest. And once they arrested that person, they're questioning him to elicit some incriminatory statements. So that's when custodial investigation happens. When a person is arrested and the questions told him or said to him are not anymore a form of general inquiry. Okay? But at the same time, when a person is invited by, for example, the NBI or the police to appear and testify or tell any admission, that is a form of custodial investigation already. Okay, so what does the Constitution say about the rights of a person once he is placed under custody? Okay, so our basis for that is Article 3, Section 12 of the 1987 Constitution. Okay, it says here, any person under the investigation for the commission of an offense has the right to be informed of his right to remain silent and to have competent and independent counsel, preferably of his own choice. So, the authorities should say to the person under custody that he can opt not to talk, not to say anything. All right, and the person arrested should be told at the same time that he should have an independent counsel. Now, we understand that not all persons can afford the services of a lawyer. This is why the Constitution provided that if the person cannot afford the services of a counsel, he must be provided with one. Okay? And there are cases in the Supreme Court saying and mandating that this counsel should be very independent, like the counsel should not be part of the police force. Okay? The counsel is, for example, from the public attorney's office, or the counsel is not the prosecutor, not the judge, but really an independent counsel that is separately employed from the police and those authorities in charge for incriminating the person under custody. Okay? And these rights cannot be waived except in writing and in the presence of counsel. So whatever rights you have while you're under investigation should not be waived if you're not with your independent counsel and if you have not written it. Verbally saying that you are waiving these rights will be deemed void. Okay? And at the same time, you must remember that no torture, force, violence, threat, intimidation, or any other means that vitiate, that influence, that crushes your free will, okay, shall be used against you in case you are arrested or a person is arrested. There are secret detention places, and you will be tortured somewhere, or you'll be hidden somewhere that the public does not know, or your family cannot know. That's prohibited. Okay, it's one thing to say that these things are prohibited or these are your rights, but what are its effects if these rights are violated? Okay, so in case your rights are violated and you confessed and you signed anything without the presence of a lawyer, whatever you say, okay, will not be obtained as evidence against you. That's what the Supreme Court calls the fruit of a poisonous tree. The fruit of a poisonous tree cannot be used to convict you, okay, to prolong your stay, okay, under custody. At the same time, the law shall provide for penal and civil sanctions. So, if somebody violates your rights while you're under custody, they can be imprisoned and they can also pay you money. How does that happen? Okay, so here let's enumerate some of the crimes under the revised penal code, okay, that defines these crimes in violation of your rights according to Article 3, Section 12 of the Constitution. So the revised penal code has this in Article 124. Arbitrary detention. So what is arbitrary detention? That is any public officer or employee without legal grounds detains you, restricts your freedom. Okay? So if they have, that's why it is imperative for you to ask if you are being arrested or you're being taken into custody, sir, what did I violate? What crime did I do? It is needed because if you have no crime, okay, they have no right to arrest you. And if they arrest you or place you into custody, they can go to prison. Okay? And the next is Article 125, delay in the delivery of detained persons to proper judicial authorities. So, for example, they arrested you. They should file a case against you. Okay? That's the meaning of delay of being turned over into the custody or turning you over into judicial authorities. They should file a case against you. If they don't file a case against you, you should be released. Okay. And then, what if, for example, there's an order for your release, but for some reason, just for a gimmick or for a power trip, they keep you. They don't want to release you. They don't want to release you, even if they have the papers. So that's also a crime. That's Article 126 of the revised penal code. That's delaying release. Now, what if, for example, a public officer, whether he's a police or somebody in government, who wishes to expel you from your home and force you to flee abroad? That's called expulsion under Article 127 of the revised penal code. Okay, that's also a crime. They can go to prison because of that. Alright, so and then we have this one, Article 128, violation of domicile. Okay, what does this mean? If a public officer without a proper judicial warrant, okay, to search you, to arrest you, goes to your house and he knocks and then you refuse him, and then but he insists, or when you found him inside your house and then you're asking him to leave and he refuses, okay, that is a violation of domicile. And that public officer, okay, if he has no legal basis to enter your house for purpose of searching your house or arresting you, that is a violation of domicile. He can go to prison because of that. And what if, for example, they have a warrant, okay, but the warrant was maliciously or wrongly obtained, okay, or with abuse of their discretion? That's a violation under Article 129 of the revised penal code, and they can also go to prison because of that. Okay, and then Article 235, that's maltreatment of prisoners. Any person who any public officer that that has a legal grounds to arrest somebody and maltreats the person under his custody, that's maltreatment, and he can go to prison because of that. All right. Now, earlier we told that the Constitution says that in violation of your rights, there will be penal and civil sanctions. So the penal sanction for the violation of your rights are discussed previously through the revised penal code. Now, what about the civil sanctions? Okay, Article 100 of the revised penal code says that every person criminally liable for a felony is also civilly liable. Okay, civil liability is through, first, moral damages, second, actual damages, and third is exemplary damages. So let's discuss those. Okay, moral damages include, okay, physical suffering, mental anguish, fright, serious anxiety, destroyed reputation, wounded feelings, moral shocks, social humiliation, and other similar injury. If you experience this while you are being taken into custody, okay, you can claim for moral damages. Now, there's no specific amount for moral damages, but you have to prove in court what you actually suffered. You have to testify, okay, what you experienced and how you felt about your experience. And when you have proven all of these elements, actually even your testimony can be enough to prove, then you can be awarded moral damages. And then there's actual damages. For example, a police officer would delay your release or arbitrarily detain you, okay? And then you have a job, okay? Or you're going to school, or you're supposed to be earning money, but because you were detained, you were not able to earn money, okay? And then your salary for the day was not given to you. Then that's the actual damage. Whatever you have, suffered in terms of money, in terms of your salary, in terms of your hospital bills in case you were maltreated, okay, those should be returned to you, all right? And then the third is exemplary damages. Exemplary damages, it is awarded to a person when there's an aggravating circumstance. Okay, that for example, there's a crime done and the public officer generally did something more than the commission of the crime to you, that gave you that made the crime more aggravating or worse than it is. Okay, you will be awarded with exemplary damages. Or for example, in terms of contracts or quasi contracts, okay, the civil code says that if there are, if the person wantonly or negligently, okay, or recklessly or with fraud or oppressively violated your contract with that person, you can be awarded exemplary damages. Now, you can collect all three: moral, actual, and exemplary, depending on how you would allow yourself to be examined in court, like in terms of your narrative, your testimony. And what if, for example, you're going to ask me, "Sir, I don't have money to pay a lawyer." Well, first you can go to PAO. We know their PAO_executive at Yahoo or gmail.com. Their email is available in their website, in the public attorney's website. Okay, and I've experienced that they provided for a lawyer. But in case, for example, that you hired a private lawyer and you were awarded exemplary damages, this is how it will go. Attorney's fees shall be awarded to you. So, for example, whatever you paid for your attorney, okay, it shall be returned to you by the losing party when you win exemplary damages. All right. Okay, so let's recap. So, what would happen if if a person's rights under custodial investigation would not be observed? First, as to the admissibility of evidence and the liability of public officers. As to the admissibility of evidence, whatever you say, whatever proof, evidence they collected in violation of your rights will be inadmissible. It means it cannot be used against you. Okay? They can't. It just can't. It will be disregarded. Even if that's a real evidence, you actually did it. Okay, but they violated your rights, it will be inadmissible. Okay, and the next is the liability of public officers in charge of custody. Well, they could go to prison. At the same time, they can pay you money through damages, moral, actual, and exemplary damages. So, this is why it is important to know your rights, especially in these trying times. We need to help each other. At the same time, when as needed, enforce your rights. Nobody else can enforce your rights but you. So I hope you learned something for this, for this teaching demo. And if you have any question, please feel free to let me know. All right, take care.